Ladies and gentlemen, we are moving forward and we have two plenary sessions ahead. And the next one is dedicated to responsibility of the Russian Federation for wartime environmental damage in Ukraine. Moderator of this discussion is Tinatin Gelatiani, K International Expert, EU Project Pravo Justice. Please proceed.
Thank you. Good afternoon, ladies and gentlemen, and welcome back. As noted, yes, our next plenary session is dedicated to the responsibility of Russia for wartime environmental damage, and it is a well-established principle of international law that every international wrongful act of a state entails international responsibility, and the state responsible for an international wrongful act must make full reparation for injury caused. This principle applies to breaches by a state of its international obligations relating to environment as much as it does to breaches of other areas of international law, such as the crime of aggression or act of aggression, war crimes, and etc. As we have heard many times today, Ukraine is already advancing accountability efforts and extended to environmental damages as well. And therefore, our discussion with our panelists today will touch upon the array of salient and pertinent issues of state responsibility under international law and the challenges of establishing and securing responsibility of Russia and practical steps that Ukraine, hand in hand or shoulder to shoulder, is taking with the international community in this direction. And we have indeed distinguished speakers who will open up and explore this topic with us today, and we also might have one or two surprises for you. With us today we have Irina Mudro, Deputy Minister of Justice of Ukraine, who has been in the forefront of Ukraine's efforts to establish responsibility of Russia for its international law violations. We also have Mr. Timofey Milovanov, President of Kiev School of Economics and Associate Professor of University of Pittsburgh, and the Kiev School of Economics has been involved in assessing, documenting and studying the damages and damages caused by Russia, including damages to environment. We also have a pleasure of having Mr. Yuri Parkhomenko, partner of Foley Hoke, who has a stellar background in representing sovereign states in complex international disputes before the international judicial institutions, including on advancing the international environmental claims. And last but definitely not least, we are lucky to have Mr. Markian Kluchkovsky, even though online, but still the Executive Director of newly established Register of Damages. Mr. Kluchkovsky, I hope you are hearing us. We definitely see you. Good. So without further ado, I would like to first turn to Madam Irina Mudra and actually ask you the question that what are the ways in which the government of Ukraine is raising the issue of the responsibility of Russia, including for environmental damages? And today we've heard many speakers touch upon the issue of the compensation mechanism and the issue of reparations. And in this regard, could you please shed the light on this issue and whether the environmental damages is one of the topics that will fall within this compensation commission? Thank you.
Thank you, Tima. First of all, I'm very pleased to welcome all the distinguished participants of this event. This event is very important in terms of bringing Russia to account for war crimes, for atrocity crimes, for all the damage and destruction caused to Ukraine and to Ukrainians. There is no sphere in life and in business activity that was not affected by the war of aggression of Russian Federation against Ukraine. And today we are talking about the category of damage that the consequences of which will be felt by for many years to come. War against Ukraine caused large-scale environmental damage, resulted in unprecedented pollution, disruption of ecosystems, and physical destruction of biological species, both on the territory of Ukraine and on the scale of the entire region and the world. The size and scope of this damage is yet to be fully calculated and appreciated, but various studies estimates that the assessment of environmental losses and damages to be in the tens of billions of dollars. But I will better leave for Timothy from Kyiv School of Economics to provide update on the recent calculations of the environmental damages, but the figures are really horrifying. Environmental degradation and destruction as a result of war harms not only nature itself, but it also exacerbates the issue of food and water loss, destroying thousands of people's livelihoods. Therefore, the response to the environmental damage, among others, should be fast, inevitable, and direct. That is why particular attention is paid to ecological safety measures in the proposed by President Zelensky peace formula. And this is the precondition why we strive for creating of effective reparation mechanism for compensation of damages caused by the Russian Federation aggression, including the environmental damage within the framework of the implementation of point 7 of 10 points peace formula, which is called restoration of justice. Since nature has no borders, the consequences of the damage also affect other states, other countries, the entire ecosystem in general. And precisely because Russia's conduct is a serious breach to peremptory norms of international law, affecting all states are entitled to address it, including by ensuring that Russia satisfies its duty to pay reparations. Previous international humanitarian rules provided the environment with very limited protection in the context of international armed conflicts. Let's just remember Iraqi-Kuwait armed conflict in 1990, when Iraqi forces overtook Kuwait in a quick conquest. In response to the invasion, the United Nations marshaled an international coalition which ultimately drove Iraq out of Kuwait. However, the consequences of Iraq's occupation and the retreat from Kuwait, which lasted less than 6 months, they were devastating. A 350-square-mile oil slick in the Persian Gulf, thousands of dead or dying birds and other wildlife, and over 550 burning Kuwaiti oil wells. It was the legacy of Iraq's occupation. And this led to the introduction of new terms in international law like ecocide and environmental terrorism, which described Iraq's actions. And on April 3, 1991, the United Nations Security Council passed the resolution holding Iraq liable under international law for any direct loss and damage, including environmental damage and the depletion of natural resources as the result of Iraq's unlawful occupation. And the United Nations Compensation Commission, which was created by the Security Council resolution, it included into the categories of damages and losses the environmental damage. So at the end, this was also resulted, and the war against Ukraine resulted in the fact that in the end of 2022, the experts of the Commission of International Law developed new mechanism for the protection of nature during and after the end of an armed conflict. And according to principles on protection of the environment in relation to the armed conflict, adopted by UN General Assembly in December 2022, the internationally wrongful acts of a state in relation to the armed conflict that caused damages to the environment automatically entails the international responsibility of that state, which is under the obligation to make full reparation for such damage, including damage to the environment. So it means that we do not need to wait Russia's consent to make reparations. These obligations has already arisen. And UNGA resolution of November 14th, 2022 on furtherance of remedy and reparation against for aggression against Ukraine made it very clear to the aggressor state that Russia, that the war of aggression initiated by Russia carries a cost, carries a high cost, which the offending country must pay. Thus, the creation of an effective mechanism to obtain reparation, including compensation, and not only to the state, but to the very victims of this blatant war, is legally now justified and follows the example of United Nations Compensation Commission. So the mentioned resolution also recognized the need for the establishment of the international mechanism for reparation of damage, loss, and injury caused in or against Ukraine by Russian Federation. This compensation mechanism, which was presented by our state and supported by our allies, by like-minded states, comprises the three main components of this compensation process. First, it's the record of damages, which is to be done by the International Register of Damage. Second, it's the awarding of the compensation sum for payment, because it's not enough just to record claims and to collect documents evidencing the damages, although it's a very important step, but it is not the ultimate goal of our country, of our government, and of our people. We want the state to get compensated for the damages. And third, which is closely related with the second, it's the fund, the creation of compensation fund from which the compensation will be paid. So also comprehensive approach would encompass that all categories of damage caused by aggression, including environmental damage, should be subject to compensation. So given the scale and gravity of these harms and the critical need to documenting and assessing the extent of the destruction, as well as fixing the victims' claims to obtain reparation, UNGA's United Nations General Assembly strongly recommended to member states to create the International Register of Damage. So such a register has now been created by the Enlarged Partial Agreement of the Council of Europe. It is hosted by the Netherlands. It is in the Dutch jurisdiction. So once all the statutory bodies are at place, rules and procedures are developed and approved, the register will start collecting and recording claims and evidences on the damage, harm, and injury from the victims, from individuals, businesses, from municipalities, and the state caused within the territory of Ukraine on 24th or onwards of February 2022, and in the result of Russian aggression. I will also leave the floor to, pass the floor to Markian to update on the status of launching of the register, because he was appointed as the general director and proposed by the government of Ukraine, and he will update on what's going on in the register. But what I just want to say that all of the rules and procedures to be developed by the board, by one of the governing body of the register, the Ukrainian government is not waiting for the governing bodies to be formed, and we are already preparing a proposal which provides that the types of damages that will be subject to compensation must necessarily include damage caused to the environment and environmental resources, damage caused to land and water resources, atmospheric air, loss of the forest fund, and damage caused to the nature and reserve fund. and other damage related to the environment or climate. So the establishment of the register constitutes a very important and significant step, but it's not the final goal. It's just the first step of the international compensation mechanism, which was explicitly invoked by UNGA resolution in November 2022. So the letter called on member states also to establish the mechanism for reparation, because unfortunately, with the claims registered in the register, no one will be able to go through legal proceedings to execute these claims. That's why there should be a special administrative body, fact-finding body, which will award the amount of compensation to the victims who will be applying. So lawyers now are working on the legal grounds for the creation of the compensation commission, because, as I said, it won't be a judiciary body, it will be an administrative body. It will be created without the consent and agreement of the state which commands this war of aggression, and there should be very solid legal grounds in order that this mechanism is legitimate and could be enforced through the compensation fund. So the obligation of the Russian Federation to pay compensation and the corresponding right of Ukraine and persons injured by Russian aggression arises directly from Russia's breaches of the international legal obligations. And this obligation to pay compensation, as I said, is not conditional upon its consent. It arises as a direct consequence of the commission of the internationally wrongful acts. That's why Ukraine urged the states, urged our allies, those states who voted for the resolution on remedies and reparation for aggression against Ukraine, and I will remind 94 states supported that resolution, voted for. So Ukraine urged the states to invoke the responsibility of Russian Federation by available lawful means, which are provided by international law, and the justification can be drawn from the provisions of articles on responsibility of the states for international wrongful acts. Article 48 could be used for that allow invocation of a responsibility by a state other than an injured state. And we understand that with the Security Council, which is unable to act in our particular instance, as it acted in the instance of Iraq-Kuwait conflict, the acting in the furtherance of the already adopted resolution by General Assembly of United Nations, the states can take actions to establish by an international agreement, multilateral international agreement, a political and administrative fact-finding mechanism based on the premise that Russia is liable under international law for damage, loss, and injury caused to Ukraine. So, and such mechanism will work in the interest of the injured state, for Ukraine, and individuals and entities in Ukraine. That is why Ukraine, together in cooperation with the International Register of Damage for Ukraine, will soon propose to our allies, to our partners, a draft of international instrument seeking to enforce an existing obligation of Russia to make full reparation for mass breaches of international law. And this shall be served as a legitimate basis for creation of the compensation mechanism and repurposing of Russian sovereign assets. The last but not the least, to say that for Russia to pay the damages, it's not merely an ethical and moral imperative, it's a legal obligation under the international law principle of state and responsibility. And since Russia has committed egregious violation of international law, it will be and owes the obligation to make reparation. It will be proportionate and non-punitive. It will be restorative to temporarily deny Russia protection of sovereign immunity and to make Russia pay reparations by repurposing Russian assets, Russian sovereign assets, as the main source of paying the decisions of the compensation mechanism. There are also legal issues around the sovereign immunity, and it is very heavily discussed in the legal community, academic community, and on diplomatic and political arenas. But we do believe that international law provides enough grounds, enough legal basis for lifting or taking temporarily measure to deny Russia protection of sovereign immunity. And the states could also use the countermeasure, collective self-defense, in order to justify this temporary measure. It will also serve as a policy of deterrence. Any state considering a future war of aggression will see that Russia's aggression, Russia's violation of international order carries a cost. Taking hold of Russian state assets is an in extremis remedy, but it responds to extreme challenge to international peace. Thus, there is solid legal ground for such countermeasures. And what is needed here? The political will is needed. Once the political will is available, the lawyers will find the ways and will find the grounds for repurposing of Russian assets.
Thank you very much. And I would like to underscore and stress that you and your colleagues have done an incredible job in actually advancing these efforts, which we all know that in international law takes even more time and even more pushing. But you stressed about the need for these mechanisms, the novel mechanisms, to be comprehensive and effective. We also know that this is a very time-consuming. And as you say, engaging more and more states means more and more political will, which takes time. So in this regard, I just wanted to ask you whether you see there any interim or provisional measures or steps that Ukraine could take or is advancing already to meanwhile the final establishment and moving the forward launching of the compensation mechanism.
Well, you're perfectly right saying that it's a long-term process. It will take time. We lawyers are aiming at modifying international law, which is not an easy thing at all. And of course, for any actions with regard to immediate actions with regard to curing the ecosystem, the environment, we need finance. We have to understand where this finance to get. And of course, no one will argue that it should be Russia who should pay for any reconstruction, for compensation for any damage. In this respect, there are ways, and we are considering and discussing various ways of using Russian assets temporarily until the compensation mechanism is created and until the legal issue of sovereign immunity is resolved, in order to make these assets to serve as an interim solution. And these can include using windfall or other proceeds of such assets. And now it is very actively discussed in the European Union with the European Commission. And I do hope that the solution will be found. And you know that recently Belgium announced that they have almost 200 billion euros frozen of Russian assets. So our legal team, together with Markian from the register, they are discussing the possible ways of using these additional windfall proceeds from the frozen Russian assets in order to use them for the immediate immediate measures, urgent measures to restore safety of environment and ecology.
Thank you very much. I think we could move to our next speaker, Mr. Milovanov. I think the Kiev School of Economy has been doing extensive work in identifying, documenting, and assessing the damage. I think you have a surprise for us. This will be as much a surprise for you as it will be for me. Would you like to say a couple of words before we switch on the video?
Yeah, sure. That's not a surprise. It's just future. I thought I'm here, so I need to focus more on the content, on what I say, rather than how I say. And what happens is that as I prepare for the presentations, for panels, I then lose control over what I want to say, and I miss some of the points. So I thought I create a video. Oh, it's not a video yet. Soon there will be a video. It's an avatar. It's an AI avatar of me, which is going to run a presentation. So this is how it has been done. This morning, Natalia Shapoval, the head of KC Institute, sent me the slides prepared by the team for this panel. We have run the slides through ChatGPT, advanced version, and got an outline of a talk. We then framed the talk with the points we want to make. It was humanly supervised. I did it. Natalia sent me some framings, points we want to make. I made sure that they are there. I edited it. So we have the text. Then I think Volodymyr is here. KC, yeah, you're a first-year student? Are you first-year student at KC? Yeah, first-year student at KC. Welcome to KC. He, with another first-year student, they just recorded me for 2 minutes talking about game theory and John Nash, and then created an avatar model. And this model, then we just gave it the text, and you will see it. It's 3 minutes, actually. Yeah, can we put the video on?
Today, I would like to tell you about how satellite images and drones assist us in evaluating war damages. Ukraine already has a complex data set that demonstrates the extent of the damages caused by the Russian Federation. Our system has the data from different governmental entities, unique losses to energy infrastructure and businesses, as well as additional information from satellites and drones. This information will allow us to hold Russia accountable to and demonstrate their responsibility to any stakeholders and courts. Using the technologies that we have improved, Ukraine will have a chance to demand compensation faster than countries who solely relied on documentary evidence. The war has caused extreme damages, and these damages continue to grow. In March of 2022, we have evaluated direct damages caused by Russian Federation in $151 billion. And as of September of this year, they have grown to even larger extent. We have developed a national damage assessment program that is based on drone imagery and orthophoto plans. Where it is impossible to use drones, we use high-quality and high-resolution satellite images. We, the Kiev School of Economics, as well as the partners, including the key stakeholders and organizations in Ukraine, this project is only possible with the support of our donors, including UK Aid, USAID, and European Union. We're extremely grateful to the leading Ukrainian NGOs and research institutions. Our methodology includes the collection of photo and video, identification of damages, and data processing. All the data is uploaded into the system of business analytics for further analysis. But why are we using the independent assessment of damages using drones and satellites? Is because this is quick, this is cheap, this is independent, technological, and secure. We have analyzed over 1 million buildings in 7 regions. Now, we have identified more than 90,000 damaged buildings. I want to show you an example based in the city of Borodyanka. We identified different extent of destructions in different categories: residential buildings, agriculture, education, energy, etc. We have also evaluated the aftermath of the destruction of Kakhovka Dam. Using different sources of data, we have estimated the extent of the flooding and its impact. As a result, we have identified more than 60,000 flooded buildings in Kherson and Mykolaiv
Ми
Oblast.
почали працювати з перших
We
днів
started working
з
from the
ОП,
very first days
Мінеко,
together with
Мінінфра,
the Office of the President
Мінрегіоном.
of Ukraine,
І далі ми
Ministry
працюємо з
of
усіма
Environmental Protection,
міністерствами.
Ministry of
А
Economics
зараз
and others, and
налагоджуємо і
continue to work
сподіваємось
with
на
them. And we
партнерство
are
з
currently
Мінекології і
arranging
Офісом
cooperation
Генпрокурора і
with the
Мін'юстом.
Office of the Prosecutor
А
General
також
and
з
the Ministry of
реєстром
Justice,
збитків,
as well
який
as
будують
with
в
the
Нідерландах.
damage registry
Росія
that is
заплатить.
established in the
Russia will
Netherlands.
pay.
Russia will pay.
Дякую.
Thank you.
So thank you, yeah. Thank my avatar. That's cloned, the voice is cloned too. That's not my voice, but it was based on my voice in Ukraine. I should have done it in English too. So it took us 3 hours to get it done, all of this. I also want to say that we have another new project with Office of General Prosecutor, assessing ecological environmental damages in Kakhovka region. We will be actually going there physically together with experts, with detectives, with prosecutors. We're going to be taking land samples, we're going to be putting them in the labs, and this is another example of how technologically we are moving forward. But personally, I would like to thank Irina Mudra and Markian. Irina and Markian have built the infrastructure in the world, which allows, well, you know, it has not yet collected the funds from Russia, but that's the entire compensation mechanism, and with the entire G7. Now you working on organization on register of damages in Netherlands, and I think all together we all will be able to get money back to people in the matter of years, not decades, in the amounts which are fair, not hundreds of what was truly imposed on people. But of course, unfortunately, we can't bring back people who have died. So the least we can do is to fight together so that Russia will pay. Thank you.
Thank you very much, and I think you are doing a lot, including for the ensuring the accountability, because the materials evidence assessment is the very key of how investigators and prosecutors will advance their cases before national and international fora. Now I would like to move to Mr. Parkhomenko and pose you this question from your experience, an extensive experience in international judicial mechanisms, including in appearing before the international courts and tribunals with environmental claims. Now, what are the considerations that Ukraine should be aware of while moving their environmental claims to judicial fora, international judicial fora?
Thank you. It is my honor to appear before this august audience for such an important event and join such illustrious panelists to discuss the issues of reparations. As the Deputy Minister of Justice has emphasized, efforts are underway to establish a special compensation mechanism to ensure that Russia pays. And part of this mechanism will deal with environmental damages. And it is safe to assume that this process will likely follow the established principles and practices in establishing environmental harm under international law. So I was asked to share with you some aspects related to the requirements for proving. Do we have slides? Should I click that way or this way? It doesn't work. Oh, now it works. Very good. Thank you. So I was asked to share observations on requirements for proving environmental harm under international law, challenges in proving environmental harm, and how to overcome such challenges based on some practical considerations. So when we turn to the requirements, When we turn to the requirements for proving environmental harm under international law, there are essentially three really important prerequisites that Ukraine must satisfy. First is that Ukraine must submit evidence showing the existence, nature, the extent of environmental harm. And Ukraine must show that the harm is actual and significant. It is important to keep in mind that what is significant does not require damage to be very serious. What is necessary is to show that the damage is more than simply detectable. And of course, an adjudicating body will look at the extent of environmental harm based on unique circumstances of each case. It is also important to keep in mind that in certain circumstances where the nature of a wrongful act is such that it precludes to establish the damages or collect evidence with reasonable certainty, then it would be sufficient to show the extent of damages as a matter of just and reasonable inference. And I think this principle, settled principle of international law is important, especially when it comes to environmental harm that is being witnessed within the occupied territories. The second important requirement is that Ukraine must show a causal link, and it must be a sufficiently direct and certain causal link between a wrongful act and the injury alleged. Many claims in international law fail on failure to establish this requirement. It is also important to keep in mind that a claimant state must also fulfill the requirement of the duty to mitigate damages. If it is shown that a claimant state had an opportunity to remediate damages but didn't do that, or did that in a negligent manner, then the causal chain will be broken and there will be no compensation due for that state. The third element is Ukraine must prove the monetary value of environmental harm. The good thing here is that international law does not prescribe any specific methodology for assessing the damages, so this is great. But it is important to keep in mind that international courts and tribunals will never accept a methodology that will lead to speculative results that will inflate the amount of compensation, and I will give you some of the examples. It is also important when devising these methodologies to ensure that they do not lead to double recovery, because this is strictly prohibited under international law. So establishing these three important elements frequently face evidentiary challenges that could prevent the full recovery of damages. And I will give you some of the examples from real life. So some claims before international courts and tribunals failed because of insufficient evidence to establish the existence and extent of environmental harm. For example, in Argentina versus Uruguay, where we represented Uruguay, we showed to the court that Argentina failed to provide sufficient evidence that pulp mills constructed by Uruguay posed a threat to the river Uruguay and the ecology of the whole area. And the court rejected all environmental claims by Argentina. In Eritrea, Ethiopia Claims Commission, the commission that dealt directly with damages arising from an armed conflict, Eritrea claimed that Ethiopia released pesticides and chemicals which killed thousands of livestock and injured people, but the commission declined those claims because there was no sufficient evidence. Everything that was presented by Eritrea was simply a two-page letter prepared by a couple of officials of Eritrea without any supporting evidence, and the commission said, well, that's not a piece of evidence on which you can base such an important claim. Important element that Ukraine has to keep in mind is evidence concerning the data on pre-conflict environmental baseline, because that's the reference point against which a reparation commission will be assessing the extent of injury that Ukraine has suffered. And on this ground alone, the UNCC, UN Compensation Commission, has rejected or reduced compensation claims by many claimant states. Other claims failed because of insufficient evidence to establish causal link. Again, a good example from the Eritrea-Ethiopia Claims Commission, where it rejected some deforestation claims by Ethiopia because Ethiopia didn't show that the alleged loss of trees was caused by the armed forces of another state. And the Commission emphasized that the claimant state did not sufficiently take into account some evidence indicating that the armed forces of the claimant state and the population of the claimant state also contributed to the loss of trees during the armed conflict. Some good examples in this category also come from the UN Claims Compensation Commission. For example, claims were rejected because one claimant state failed to mitigate damages. For instance, Kuwait was claiming a significant amount of damages for the remediation of detonated ordnance. And Iraq showed that one of the significant factors contributed to the detonation was the negligence in storing those ordnance by Kuwait. And consequently, the Commission rejected the claim because the causal link was broken. An important element to keep in mind for Ukraine is the existence of parallel, concurrent causes, because such causes may intervene to bring the chain of a causal link. For instance, the UN Compensation Claims Commission rejected some of the claims brought by Kuwait because, with respect to degradation of vegetation, because it was shown that before and after Iraq's invasion, that area was subject to uncontrolled grazing by Kuwaitis, and therefore the causal link was severed. Some claims in international law were rejected because of insufficient or inadequate methodologies to assess losses. A good example is a recent one, Costa Rica versus Nicaragua, where Costa Rica relied on ecosystem services approach to seek from the ICJ the compensation in the amount of nearly $7 million. So the court looked at that methodology as being not generally accepted under international law, and the court rejected that methodology and applied its own methodology, which resulted in the reduction of the claim from $7 million to $380,000. Another stark example comes from the ICJ case in DRC versus Uganda, where the DRC claimed nearly $7 billion for ecological harm and for exploitation of natural resources. But again, because the methodologies were absolutely inadequate, and that's what we showed to the court, the court reduced the amount to a bare $55 million. Just, you can imagine the drop, 7 billion, 55 million. The United Nations Compensation Commission is also in line with this international practice because, as this table shows, successful claims were awarded an average amount of 6.2% of the total amount claimed. And just compare the billions claimed by states and the actual amount that was awarded. So, as you can see from these examples,
I think, yes. Our tech team could switch the slides if you say the next slide.
Okay, next slide, very good. So as you can see from these examples, evidence is the blood in veins of legal arguments. No legal argument will fly before an international court or reparation commission if you do not fill these veins with blood of evidence, right? And based on my experience, it is really important to consider, for Ukraine right now, to consider taking certain steps that will help it overcome the challenges that I've just mentioned, evidentiary challenges I've just mentioned, or at least mitigate them in order to establishing its environmental harm. And when you look at these steps, you may think, well, this is very obvious, it's very simple, but you will be surprised that in reality, few states, based on my practice, followed these simple steps. So let me briefly, and by the way, those that didn't follow these steps, so they ended up with really losing badly before international courts and tribunals. So the first step of critical importance involves establishing a coordinated system for collecting, assessing, preserving evidence which is necessary to meet international requirements to establish environmental harm, all those requirements that I've just mentioned to you. This step is really indispensable for success. We know that there are different types of environmental harm, and they fall within different agencies with different competencies, with different capacity to deal with evidence. And it is really important to ensure that through the emplacement of this centralized mechanism, there is no silos effect among each agency. And instead, each agency is connected to each other. For example, the Office of the General Prosecutor, who has done an incredible work in collecting all evidence to establish criminal liability, can cross-pollinate the activities of the Ministry of Environment and vice versa. So there must be communication on the interagency level. It is also important to ensure the coordination between Ukraine and international organizations, because what I frequently see in my practice before international courts and tribunals, different international agencies may present different conclusions which are based on different pieces of evidence. And if you do not coordinate these efforts, right, then you will have a simply fragmented picture which causes an anxiety or confusion before international courts and tribunals. And I would like to highlight as a very good example the recent work of the Ukrainian government and the United Nations on calculation of damages with respect to the Kakhovka Dam disaster. It is an incredible example of cooperation at all levels within the Ukrainian government and also at all levels within the United Nations agencies and World Bank and European Union. And that effort brought about a very robust and very conclusive piece of work that will have credibility before an international court and tribunal. The second step that it is important to consider is to develop environmental damages claims recognized under international law based on the forms of evidence likely to be considered as having the greatest probative value in order to convincingly establish the existence of environmental harm, the extent of environmental harm, and the element of causation. These three elements are inherently fact-intensive and scientifically complex, and it would be therefore necessary to develop first a very comprehensive legal framework and clear strategy on how and from which evidence to develop claims for each type of environmental harm. My experience shows that no kind of evidence is sufficient by itself. Courts and tribunals consider all submitted evidence in its totality and then determine for themselves which evidence they regard as having the highest probative value. Therefore, it is really imperative to collect all kinds of credible evidence to ensure that every piece of evidence corroborates each other. And in this connection, our colleague from the Kiev Institute of Economics mentioned about drone footages, and he mentioned that this would be much better for Ukraine, and Ukraine, it would be easier to establish environmental harm. That's certainly correct. But drone footages by themselves, right, would not be enough. There must be corroboration from evidence on the ground, and I know that our colleagues are doing an incredible job in collecting all this evidence, putting together. Just based on my experience in one of the recent cases where we represented Philippines against China. So we showed to the tribunal that China caused enormous environmental harm as a result of its construction of artificial islands and as a result of its predatory fishing practices. And of course, despite numerous obstructions by China, we were able to gather different types of evidence, where each piece, from documentary evidence to video footages, witness statements, expert opinions, where each was like a Lego piece in the whole puzzle and built a very solid case, finding that China breached its international obligations. The third step that is really important to consider is to develop credible and convincing valuation methodologies with experts or international institutions recognized as impartial and independent. As a general proposition, techniques and methodologies employed to assess compensation must conform to generally accepted scientific principles. They must be also reliable and must be based on the particular factual circumstances of the claim, not on conjecture or speculation. Some, for example, claims were thrown out by courts because they were based on some theoretical computer models that were really detached completely from reality. Or even if they were connected to reality, some of the assumptions in those computer models were unverifiable and highly hypothetical. And this brings to another point, that assumptions and calculations in any methodology that is being developed must be transparent and verifiable, so that an adjudicator could examine each element of the methodology to confirm that it meets all the relevant requirements. So while international law neither prescribes nor prohibits any particular methodology, certain techniques may be considered as best practice. And I think this is something that Ukraine can take into account. One technique is to estimate value of the costs reasonably incurred to remediate and restore the damaged resource. This is called the restoration cost approach. It has its limitations. We can talk about it later if necessary, but this is the first approach that international courts and tribunals look at in assessing environmental damages. Another approach is replacement costs, and this approach looks at reasonable costs to replace the environmental services that either have been or may be lost prior to the recovery of the damaged resource. And the compensation here is assessed by reference to the price that would need to be paid to preserve an equivalent area until the services provided by the impacted area have been recovered. The ICJ used these techniques in some of the cases. In Costa Rica versus Nicaragua, the United Nations Compensation Commission has routinely relied on these two methodologies as complementing each other, and most of the environmental damages were assessed based on these methodologies as less speculative and more verifiable. And as I mentioned earlier, whatever methodology is used, it must be ensured that it does not lead to double recovery. Now, the fourth step to consider is to develop and present clear and concise factual and legal arguments before a compensation commission. And you will be surprised how frequently you can see pleadings that are either incoherent or poorly structured or poorly presented. Again, such pleadings cause anxiety and confusion among judges, and of course, of inefficient advocacy or inadequate presentation of evidence before an international court and tribunal will inadvertently lead to the reduction of compensation claims or rejection of claims all together. I do not know whether the mechanism that will be established right now will provide different stages of pleadings, whether it's written pleadings, oral pleadings, or oral pleadings only. But I think it would be important to keep in mind that, at least based on the practice of the UN Compensation Commission, it should not be limited only to the presentation of written evidence, because the practice from the UNCC shows that if you submit only written evidence, that many questions may arise in the minds of the experts working on the commission. And it is better to have a follow-up oral hearings or some clarificator or like second stage where a claimant has an opportunity to provide some clarifications and use additional evidence. It is also frequently that you can see in international adjudication a court or tribunal or a panel adopting their own methodology. For instance, in DRC versus Uganda, the ICJ rejected the methodology by the DRC once we showed that it was wholly inadequate, and the court appointed its own experts. And then the court gave the opportunity to both sides to comment on the experts and also present comments on the methodologies developed by those experts. And that way, you have an opportunity to participate in the process and identify potential weaknesses in that report or beef up the evidence that may be lacking. So as I mentioned, these steps may look obvious, right? But you will be surprised that not every claimant state follows these really simple steps. But I'm sure that the efforts that have already been taken by Ukraine and the efforts that are being will continue Ukraine will continue to take will help it avoid these challenges and establish all necessary elements for environmental harm in order to be able to recover as much compensation as possible under international law.
Thank you. Thank you very much. Indeed, the evidentiary challenges generally is the key to any successful claim, and it is important that the country streamlines and optimizes its efforts in ensuring that every piece is selected, every piece is checked and put into the bigger picture, as you noted. Once again, last but not least, and thank you for being with us, Mr. Klitschkowski. We've heard, and it is really that the register of damages is the key element, the pillar of this mechanism of ensuring accountability, but also the redress to victims, whether physical or legal persons, for the damage caused. Now, could you discuss where we are standing at this very moment in relation to establishing and moving forward with the registry?
Thank you very much, and good afternoon, ladies and gentlemen. It's a pleasure and an honor to be speaking at this important event. My only regret is that I cannot be there with you physically and share the stage with Irina, Timofey, and Yuri, excellent speakers and excellent presentations that made me realize that I may not have much to add in terms of the substance of the discussion, but perhaps can offer a practical roundup of these three important interventions in the context of the establishment of the Register of Damage. Because, Tinatin, as you rightly said, the Register of Damage is the first pillar or the first phase or component of the compensation mechanism that is meant to put all that we're discussing and then some into a single context of the activity that will result in full and fair reparation to Ukraine and Ukrainians. What I say, I have to warn you that it will call back to much of what Deputy Minister Mudra has said, because we affectionately call one another partners in crimes when you talk about these things, as the two of us have spent much of the past 18 months advocating these matters and trying to build this system from the scratch. I can say that as we sit here today, just 11 months after the United Nations General Assembly resolution on remedy and reparation for Ukraine, we already have a first component of that mechanism in place. The Register of Damage has been established last May under the auspices of the Council of Europe, with its headquarters in The Hague, to serve as the first component of the compensation mechanism. We started very quickly with broad political support. We have 44 participants and associate members, 43 states and European Union, and that number is expected to grow. We will spend next week in New York, incidentally during the International Law Week, talking to other states, most notably non-European states, calling them to join the register and to make it a truly international, truly global endeavor to defend international law, to defend accountability. The Register of Damage, the purpose of the Register of Damage is to serve as a record of eligible claims for compensation of damage, loss, and injury that were caused by the Russian aggression in Ukraine. As it was said before, it is not an adjudicative body. We are not meant to issue decisions or award compensation. That is something that further stages of this process will do, and that work is ongoing. But we have a gargantuan task of collecting all that information in a clear and a coherent manner, so that all that documentation, all these claims, all the supporting evidence were properly organized, documented, and prepared for processing and for further decision making. One of the critical elements of our work is the understanding that we are going to deal with massive amounts of data and a very, very large volume of claims. In designing our systems, we have been looking and we are looking at existing precedent. But none of the compensation mechanisms or reparation mechanisms before has come close in size to what we have to build, because we have to respond to the need to record millions and millions of claims from individuals, from businesses, and from Ukraine itself. The Register of Damage and the compensation mechanism are meant to be comprehensive, which is to include every category of damage, loss, and injury that Ukrainians have suffered at the hands of the Russian aggression, including, of course, the environmental damage. The Register of Damage will be unique in many ways, but perhaps first and foremost in a sense that it will be the first such organization that will be exclusively digital. The heart and soul of the register is the digital platform that is now under development that will take in information about claims and underlying evidence exclusively in digital form. That is, if I'm honest with you, this is not because we want to be so modern and want to be in line with current trends. This is, first of all, driven by practicalities. If we imagine that we have 5 million claimants and each of them is permitted to submit one paper page of a claim, we will drown in paper. That is not environmentally friendly, among other things. So we will be all digital. This will go to help in other ways, also in the sense of ability to process the incoming data. We will not be able to do that manually. We fully understand that. And we will rely on modern technology, data processing tools, software, AI, not necessarily ChatGPT, but nevertheless AI, to process that data, to group that in a data in groups that will be able, that will allow us to manage it in a more or less coherent way. We understand that our process is a legal process. Even though it's not a judicial process, it is nevertheless legal. Therefore, integrity of evidence, comprehensive nature of evidence, and sustainability of evidence to the point that it is sufficiency of evidence, I should have said, to the point that it is enough to establish the circumstances that speak to the fact of damages caused and their volume are critical to us, and there are no shortcuts that can be taken in that extent. The development of our digital platform, as I said, is ongoing. It is a very complicated task, as you can imagine, not in the least because it must be secure. We have been warned by the recent incident of International Criminal Court having to deal with a hacking incident that's really undermined its operations, and we fully expect to be a target. Therefore, we pay a lot of attention, a lot of time, a lot of effort in order to make the system secure. The system also has to be compatible with various Ukrainian systems and databases. First of all, the existing registers, existing databases, register related to property, entitled to property, registers that have been established already after the beginning of the war to address its consequences, and also it must be compatible with the DIA system. So we're enjoying wonderful cooperation and fruitful cooperation with the Ministry of Justice of Ukraine, the Ministry of Digital Transformation of Ukraine, and many other agencies that help us build that system. We hope to be able to launch the system to start taking in claims, even if in a temporarily limited volume in the first quarter of 2024. And then after we see that the system works and it operates to the fullest of our expectations, we will build on and add another categories, including, of course, and for the purposes of this event, first and foremost, the claims for environmental damage. These claims are not easy to describe. They're not easy to prove, and they're not easy to assess. You've had excellent presentations, and I was quite frankly fascinated, not surprised, but fascinating nevertheless by Yuri's presentations about that really gives you an idea of how difficult it is to establish a claim for environmental damages. We, in many aspects of our work, we look back at previous examples of how these things have been done before. And you may have understood from my remarks that we are still, as an organization, we are in our infancy. And a lot of decisions have not been made, including what exactly going to be the categories of damage, how exactly they're going to work, and what exactly is going to be the requirement for evidence. But it is clear that we have been thinking about these things and have things to say. But I do hope for understanding that what I'm saying is not set in stone yet. It is all subject to change as discussions about these things are ongoing. In his presentation, Yuri and others, and starting, of course, with Deputy Minister Mudra, have referred to the United Nations Compensation Commission, UNCC, as an example of how environmental damages can be handled in the context of a military conflict, in the context of an aggression of one state against the other. And in many ways, UNCC is a source of inspiration for us because it is perceived by many to be perhaps the most successful mass reparations instrument of the 20th century or 21st century as well, for that matter. And UNCC had a specially dedicated category or subcategory of claims related to environmental damage. And the UNCC has received approximately 170 claims seeking approximately $85 billion of dollars of compensation. You've seen all those figures already on the slide, so I should not repeat them, just except to emphasize that the awarded compensation for environmental damage constituted only 6.2% of the amounts claimed. Again, saying that this is a difficult case to make, difficult category of damages to prove. But nevertheless, it is a substantial amount, and we can learn a lot of lessons from that. The types of environmental damage that were compensated by UNCC included first and foremost consequences of oil spills and oil well fires, landmines, destruction of vegetation, loss of wildlife, depletion of groundwater, contamination of soil and water, disruption of ecosystem services, as well as costs related to monitoring the environment and its impact on the health and well-being of local population. We are also learning how the work on submission and handling of those claims was structured. For example, the general standing to make those claims belonged to the governments to make claims related to environmental damage. The governments or international organizations that have suffered damages. And they were supposed to file claims on behalf of themselves and on behalf of other entities that suffered environmental damage as a result of Iraqi invasion of Kuwait. Perhaps the same type of approach should be followed in our case. Perhaps it is the government that should be the primary claimant with respect to environmental damage. And the question is whether a possibility for other entities and individuals to file such claims is to be opened. In UNCC, there was a limitation period during which these claims were supposed to be filed. The deadline for submission of those claims was the 1st of February 1997. So more or less 5.5 to 6 years after the conclusion of the conflict. Of course, in our work, we can never put a deadline in a situation where the war is ongoing. There is no deadline as we sit here today. But we have to be mindful of the fact that evidence must be collected as quickly as possible because it is simply getting lost in the fog of war, as the saying goes. There are also requirements as to how the claims should be put together with a statement of claim, a summary of the claim, supporting evidence and documentation, and an estimate of the amount claimed. The NCC generally has adopted a quite unique and innovative approach to deal with these claims, which involved the use of expert panels, scientific methodologies, and technical standards that had been developed by the organizations working in this field, primarily by UNEP and others. It is very encouraging, and again, unsurprising, to have heard Timothy's saying that these missions are ongoing to collect evidence with the use of experts, with the use of proven scientific standards that will allow proper, sustainable, and admissible collection of evidence. And of course, the Kakhovka catastrophe is just the one of many examples, even if perhaps the biggest and the most notorious examples of environmental damage. The work of the UNCC has also developed or elaborated on other existing standards for handling environmental claims, such as the requirements of causation, mitigation, reasonableness, and proportionality. Yuri has spoken at length about causation. I should not repeat any of that. Mitigation is the need of the government, in this case, the Ukrainian government, to take steps to minimize the environmental harm and not just sit and wait till something happens, because those actions will be taken into account in assessment of these damages. Reasonableness and proportionality go to trying to assess what exactly can be done about this or that environmental claim. The peculiar characteristic of environmental damages and assessment of those damages is that their methodology is not to establish how much it cost, how much the previous ecosystem cost. The assessment of damage usually equates to the cost of what will it take to reinstate the system in a state that it was as close as possible to pre-existing. So the proportionality and reasonableness of those calculations, of those approaches, play a very important role overall in establishing the perspectives of the claim for being accepted. All these principles we want to rely on in building our approach to registering environmental damages. There isn't yet a list of categories, as I said, that will be recordable in the register. But insofar as environment is concerned, it is pretty clear that we will be taking a look at damages related to environmental pollution, and not just pollution in a sort of traditional industrial sense of that word, if I can put it that way, but also pollution by landmines, pollution by military equipment, and unexploded ordnance. We will be taking a look at the loss of biodiversity and disruption and loss of ecosystems. We've heard examples from the south of Ukraine about the regions of Kinborn, and of course, again, with the consequences of the destruction of the Kakhovka Dam, with entire ecosystems and entire areas being put in jeopardy. We will be taking a look at other consequences of the war with respect to the environment, particularly those related to the climate, including an effort to see if there is a way to claim compensation for war-related greenhouse gas emissions. And finally, of course, we will see the impact of environmental damage on other spheres of lives, including health and well-being of people in Ukraine, people in the affected territories of Ukraine. As I said before, we are some ways away from being open to receiving those claims. But it is already perfectly clear that no time should be wasted in working to collect and organize that evidence, to engage with experts, engage with scientific community to develop a way to quantify the environmental damage on this nationwide scale. That's probably not a big exaggeration. There is also an important task to try to break down all these vast amounts of information, to break them down into individual claims that will have been submitted, that will be submitted to the register and ultimately decided by the Claims Commission. As we have seen from the UNCC experience, it is not a single claim for all environmental damages that is being submitted. These are claims that relate to a certain identifiable area, certain identifiable subject that can be explained, proven, assessed, and evaluated. So we expect the government, and we know that the government is working on this together with international partners, both on national level and international level. There is massive engagement of NGOs that work in this space. The work of organizations such as KSE is difficult to overstate, not only on the issues of environmental damage, but more generally on assessment of damage caused to Ukraine. So there's a lot of work to be done here, and we should not find solace until we complete all that work. From our perspective, we continue building the system of reparations. The register is yet again just the first step in this process. We truly hope that we will be able to build a claims commission in the near future. I'm sure that there will be updates quite frequently on that point. And the work on the use of Russian assets, whether it's through confiscation or otherwise, is ongoing. It is now more active than ever. Perhaps it's fair to say that the ice has broken in that discussion, and we have gone to not discussing whether we can use the Russian assets, but rather to discussing how we can use the Russian assets in a most efficient way to make reparation to Ukraine. So there's a lot of work. I'm glad and honored, and I appreciate the ability to work hand in hand with people like those sitting on the stage. Once again, I'm really sorry that I cannot be with you, but I'm sure that we will have a chance to see each other and to cooperate in the coming weeks, months, and years. Thank you very much for having me.
Thank you very much. I was just told that we might have a power cut. That's why I tried to warn Markian about that. But thank you very much. I would like to thank once again our speakers. I think there is no single legal mechanism to advance the claims and the state responsibility of Russia. However, as Deputy Minister said, the international law is flexible enough to based on the basic principles to advance the accountability efforts. And Ukraine is going rightly and strategically in this direction. Thank you very much. I wish Ukraine all the best in its efforts.
Thank you very much.